Good morning, Dr. Barry, London News. Good afternoon, good evening, wherever you are in the world watching this video. This is a brief introduction. At the end, I'm putting one of John Smith's common law court in the UK. About 6 months ago, he was on a channel. I'll show you that. And I'm going to tell you the reason why he was removed from the common law court itself and his website taken down. He was a very naughty boy. But first of all, here in Australia, as you know, we have set up the Sheriff's Office, and there is a video on the channel here already telling you how the sheriff started in 1635, got the common law and the sheriff system to the United States, which is still operating today, and it is not subject to the attorney generals or the governors or whatever the case may be. They are subject to the people who elected them. The same thing has taken place here now. We've got our own common law court set up with the Sheriff's Department, Sheriff's Office. We're an independent organization owned and controlled by the people and not subject to the statutory system by any means whatsoever. As for the video you're going to see in a few minutes with John Smith, he was a master of common law. He was brilliant. Sadly, some of the people who I've met in England when I was over there in August, they sponsored him with money and lots of support, training not special constables, but peace constables to help enforce it. But Smithy got money from a lot of guys. They put this money into making money, and they turned the whole thing into a flaming joke and has done more harm to common law. Now, I personally owe John Smith gratitude for everything he's taught me, and of course Kevin Arnott, who started it all up, he's gone with the wind as well. But Smithy described things by issuing common law plates with no insurance, selling insurance for £250, which you multiply that by 2 to get an Australian dollar. And it turned out to be an absolute hoax because people lost their cars, and which would happen here. And we will never do such a stupid thing there, even though Vic Roads in here in Victoria and the same authorities around the country are monopolizing the insurance thing, which is not lawful. But that's down the road to be taken into consideration. So have a look at John Smith's video. There's a lot to learn. He talks about IDs and he talks about the system, and the guy interviewing him is very, very good, and we thank him for his support, or sorry, for the use of his channel. I did say that on the channel. So without further ado, let's go across and have a look at this video. And remember, support your local sheriff. We have set up the Earls of Liberty Society, which will help run the common law court, because the common law court can have a committee. It's independent, it's run by the people, but on the side, the Earls of Liberty Society has been set up. You can join up as a member. You will get a pin in the shape of a sheriff's badge to say that you are a member. And remember, it only takes 2,000 people in a society to prevent a bill going through Parliament. In other words, if they put a bill up, people don't like it in that society, 2,000 members can actually promise to pay that bill so it doesn't even get read for the second time. That's another asset of having the society on the side running the common law court and the sheriff's office, which we're now promoting the sheriff's office more so than anything else, because common law is confusing to most people because they argue against it because they don't understand it. So let's promote the Sheriff's Department, or correction, we're not a department, never will be, the Sheriff's Office. Look, I'm human, I make mistakes. Okay, without further ado, let's pop across and have a look at these videos. Bye for now.
And my guest is John Smith from the Common Law Court, International Common Law Courts, and we chat about all sorts of things.
The church, you can't do that. You have to have something that you can use day-to-day basis. He agreed and he says, yes, but I'm not doing that. I said, well, we should do that and set it up. So I said we'd do that, but also he only dealt with criminal actions by the state. I thought, well, you can use it for civil actions as well.
Well, I think, John, this is one of the problems that the whole system suffers from at the moment, which is that 99% of court hearings or summonses are civil anyway.
Yeah.
We're not all murderers and rapists and God knows what else. So when you look at it on a percentage scale, the very much larger side of it is civil, you know, with contracts and, well, or should I say unilateral contracts rather than contracts
Mhm.
from different authorities, utility companies, whatever
Yep.
it might be.
Yeah.
And then you've got a very small percentage,
Mhm.
which the criminal ones, which,
Yeah.
I mean, as far as I'm concerned, I have no problem with criminal legislation
Mhm.
because it follows perfectly, harm, injury, or loss. Well, if you've screwed up and you've caused that upon someone
Yeah.
else, then the full force of the law can be
Mhm.
placed upon you. But when
Yeah.
it comes to civil liberties and
Mhm.
civil courts,
Yeah.
and the administration thereof,
Mhm.
that's where the rip-off takes place.
Yeah.
Because they are, I could not have envisaged, if I lived in the 15th, 16th, 17th century, to anyone coming up with the idea of a victimless crime.
Yeah.
Which is exactly what most of the, you're going 5 miles an hour over a speed, an arbitrary speed limit.
Yeah.
And now you're being fined, and it's like, well, who's the victim?
Mhm.
And who was harmed and who suffered loss? Well,
Yeah.
none of those things. Well, then technically, there's no case under not just common law, but bloody common sense.
Yeah.
But sorry for interjecting there.
No, it's okay. No, you're quite right. But obviously, these were the sort of issues we looked at, and I thought, well, if we're going to do something, it should be applicable for everyone. But the other thing being, it has to obviously be simple for people to follow, and it has to go back to the basics: harm, loss, and injury, and obviously honourable in your contractual dealings. I said we keep it down to the basics. That's all it is. Now, when we actually thought about that, I said, well, what we'll do is I think we're going to convene a court. Well, I will convene a court. It was to deal with issues. Now, I wasn't actually looking for anything financially. I was looking for a ruling to confirm that what happened to me was a criminal offence by the state. It was crimes committed by the state. So I says, well, look, I'm going to do this. I'm going to convene a court case and call on the public to attend. So we went through and we had a set procedure. So we issued a public notice. We made the information available to everyone, put it up on the internet. Now, I had, at the time, been living in Aberdeen, but I decided if I'm going to do this, we cannot allow anyone to have a pop at this, meaning the government, because if we do it, it has to be done correctly. It has to be, we cannot simply use a mirror image of what they use. We have to have something which does provide a lawful remedy and is untouchable. He says it has to be honourable. You have to have used this correctly. It has to be for a lawful remedy, and it has to provide justice. The courts could be legal representation, could be lords, it could be anyone they want. Everything you do, including legislation, they're saying it's done for the people. It's not, because it's created by people with titles. Now, forget all that. Forget everything. Forget the definitions you've given, right? All we're stating is a trial by a jury of your peers, and that's it. Now, under common law, we only ever deal with living men and women. Now, it says if someone turns up on the day and they do not obviously appear as a living man or a woman and confirm that fact, they can't take part in this because they're then within the corporate system. Now, basically, it says we have it. It's just simple. It's a jury. It's called. The peers are selected randomly through the public. We select 12, a minimum of 12. You can have more if you want, but we obviously only accept decisions which are unanimous. So for a guilty verdict, that has to be unanimous, simply because any reasonably minded man or woman can tell you right from wrong.
You just hit the nail on the head, John, right? A trial by jury is literally the jury has control over that trial, and the result has to be unanimous, right? In the system, a jury trial, right? The judge gets the say, and you only need a majority. And that's the difference between the two. So, you are being tried by your peers, not the judge.
What we're actually doing just now is they use terminology for everything. It doesn't matter.
Of course they do.
Now, basically, anything that they refer to or relate to, we just ignore it completely because we have nothing to do with them. So if you come back to basics and say, look, we're dealing with it here, what we're going to do, he says, we have a system, he says, whereby we provide a lawful remedy for people, but it's decided by the people, and we will have a lawful jury, a jury of our peers, and that's it. The decision is decided by the jury. We have no interaction with the state at all because they're corporations.
So the question then remains is, so what about enforcement and consequence?
Well, having done that, he says what we need to do is establish certain things. Now, up until then, up until we had the first hearing that I had, up until then, there is no actual verification that what's actually happened is a crime under their system. So if you go to their courts, they'll never admit that they're committing crimes against the people. So by using this process, what we had to do is establish our position and establish decisions from the court. So we obtained decisions to confirm that they are committing crimes against the people. So we've done that. But similar to the next step, there's no point in doing something if you can't move forward with it. So
Yep.
the next step is looking at enforcement. Now, in relation to enforcement, we have 2 MPs who have resigned. One of them had been promoted and went to the House of Lords because they resigned from a cabinet minister we prosecuted. We've actually had a bailiff firm in England that actually refused now to process council tax debts, because we obviously we found that we obtained a guilty verdict against one of the bailiffs that was trying to enforce this, and we passed on to the company, but the company immediately didn't want anything to do with it, and they wrote to the council and says, we're not having anything to do with this now. So they've dropped away through enforcing council debt. We've actually put in a couple of judges. We've actually prosecuted 7 judges from 3 different countries. There's 4 in Scotland, 2 in England, and 1 in France. They've all been prosecuted. They've all been issued with court summonses. They've all been issued with court orders confirming they're criminals, and even highlighted one case I was dealing with in Scotland in court that the judge was a convicted criminal, having obtained the order from the common law court. Now, one of the judges didn't like what we're doing, and for 6 months, because it was a large issue, we went on and highlighted this, the fact that this judge was a criminal in relation to the issue. We've done that for about 6 months or so, eventually got fed up, and he actually took early retirement, 8 years early. Now, there's no way, given the money that they're on, that they're actually going to then turn around and say, right, okay, I'm going to retire early. This is, they're in a job for life. As you say, it's part of the gravy train, they get money for it. But we actually done that, and based on these orders, these people are obviously panicking. Now, we had in the land registry in Scotland, we have someone in charge they call the keeper of the register in Scotland. Had been in the job for years. I took her on, and eventually we got a common law court order against her. She wasn't happy about it. We notified the politicians to let them know what was happening as well. Out of courtesy, she resigned from her position. So we decided we have to do something for the people, because things like the classic ones, Magna Carta, you've got the Declaration of Independence, this is, you've got various other things, Act of Union, this is various other pieces of legislation, constitutions worldwide. The only problem with these is every one of them has been created by the state, effectively the equivalent of the state. They're not by living men and women. And I thought, well, we need something created by men and women.
Well, anything pre-Parliament assembled is the men and women. The moment Parliament was assembled, whenever it was, that statute legislation.
I would actually, statute legislation is fine, but I would also turn around and say, for example, this is even before Parliament was created, that it was still not the people. Because if you had something, for example, go back to Magna Carta. Now, I spoke to someone who ranted and raved about Magna Carta for years. He's since passed away, and I got on well with him. But obviously, this guy's all for Magna Carta. Now, Magna Carta is actually quite good because there is quite a lot in it. It's useful. And I'm aware, obviously, it can't be changed, the original one. So that's fine. However, if we look at that, the people in the UK at the time, there is no way in the world that the people would put this together and create the Magna Carta. Magna Carta was created because of the barons and because of King John and the taxations and the stealing land. So it was the barons that set this up. But the barons were aware if they went on their own to the king, it wouldn't hold any weight. So they needed to involve the people. So they created the Magna Carta and put in some of the terms and conditions to help the people, which was fine, and they then presented it, and the king was forced into a position where they had to accept it. But the point is, you're speaking about the king, you're speaking about barons, that's not the people. So even Magna Carta wasn't created by the people. So what we did is we created a document which we believe is the first one created by people. But what we says is we're going to use something now. While we speak about common law, we basically accepted that name. If most people in English-speaking countries use the term common law, they think they know what it is. So it's easy for people to understand. We'll accept it. But common law, the common law court, it's not just common law. You can call it various names. It can be natural law. It can be universal law. It can be the law of the land. Depending on your religion, it can be God's law or even the Creator's law. So it's applicable.
So we've got this distinction, and again, for the viewers, I want to make this distinction because you and I both know where this bit of the conversation is going. So you've got the definition of common law as from the people's perspective that you just mentioned.
Yeah.
And then you've got the Parliament assembled version of common law, which is based on legislative case precedent.
Yes. Yeah.
Which is what they term as common law. Yeah.
So again, it fits in. They use terminology to suit themselves, and obviously they speak about common law, but it's not common law. Common law effectively is the law of the land for the people. It says nowhere does it say that it has to be obviously the government, parliament, monarchy, the church. That's nothing to do with common law. It's not the people. So what we did is created the Declaration for the Common Law Court.
Yeah, but they have usurped, the system has usurped the very concept of the original concept of common law to make out that common law is basically the consent of the people. And then when you dig into it, you go, well, hang on a second. No, that's just basically the case law that you've said in the higher courts that the lower courts must follow. And now you're calling that common law.
Yeah, which they can't. So the point is, what we've done is, because of the distinction between that, we've put down, it says, well, we need a declaration for the people. So we put it in. Now, what we've done is we actually looked at previous documents that have been used internationally. We needed something to appeal to everyone, regardless of where you live, race, colour, religion, everything. We needed something. And we took it back, but it was actually quite good because we came up with one document. Now, it doesn't matter where you are, or obviously what your beliefs are. This has to be applicable to everyone. But in Scotland in 1320, there was actually a declaration. It was a declaration of Arbroath that was written up. Now, just to give you some background to this, I believe it's probably one of the most important documents that we have. Now, the reason for this is that at the time, people remember the Braveheart film. You've got King Edward, William Wallace, Robert the Bruce. Now, what happened is after that, after Braveheart, and obviously the battles between
and you had to get an Australian to do it.
Oh, I know. But basically, because of this, what had happened is the English, having been successful, were basically trying to wipe out Scotland, effectively genocide. They were banning things like playing pipes, carrying weapons and things like that, and wearing tartan. So they were trying to get rid of everything to do with Scotland. Now, that in itself is okay. It happens everywhere, so it's not unique. But the Scots at the time, this is to Robert the Bruce, had went to an abbey in Scotland that was used quite a lot. It was Arbroath Abbey. Now, what they did is they got one of the monks to actually prepare a letter, and it was actually a letter to the Pope. Now, the Pope at the time was the supreme ruler in the world. And what the Scots had done through this, it was a declaration that was submitted. It was an open letter to the Pope, and eventually it went along the lines, I'm not going to paraphrase, but it says, look, the English have came here, they're trying to take over country, they're raping, pillaging, committing crimes, the crimes that they're committing are unbelievable. He says, never will we accept English rule. And then they says, as long as but 100 of us remain alive, we have the right to stand together and take on anyone you want. Now, when they wrote, they started off by saying to the Pope, we as your loyal servants. So basically, they're giving their authority to the Pope, the authority over Scotland, and they says, we, your loyal servants, are being attacked by the English. We require your assistance and help to stop this crime taking place. Now, effectively, when presented with that, the Pope had two choices. So he can turn around and say, well, hold on a minute. Do I let the English wipe out the Scots, which is genocide, or as the Scots have already admitted that I'm the supreme ruler, I can protect them, and all I have to do is tell the English to leave them alone. So they issued an order to tell the English and King Edward to leave the Scots alone, which was fine. So effectively, you had this situation whereby, based on a declaration and the fact that they put down 100 people have a right to challenge anyone, that was accepted by the Pope. It was accepted by the Church. It was accepted by Parliament. It was accepted by the Crown and the people. Now, because this was accepted, even recently, about 2-3 years ago, when they were dealing with Brexit, they raised the question of this declaration in the House of Commons. There was a debate, and once again, they confirmed that if you're born in Scotland, the declaration clarifies the position. The declaration confirms that you're born free. Now, you're sovereign in Scotland if you're born. Now, when we looked at that and said, well, it's quite good, forget the mechanics behind it and the reason for it.
Yeah.
The Church have accepted it, the Pope's accepted it, the Crown's accepted it, the governments have accepted it, the people have accepted it. So therefore, if you have a body of 100 people confirmed in their belief that they stand together, you can challenge anyone. I thought, fine, well, we'll do that. So what we're going to do is we need 100 people. So we put down a charter, a declaration, and we based it on predominantly a lot of what had happened in the previous declaration, but we've updated and changed it. And our beliefs are not just for Scotland, it's for everyone, because when you're born free everywhere in the world.
Yeah.
But as soon as you're born, within a day, someone comes in and claims you, whether it's a state, whether it's a church or whoever, someone claims you, you're now in that society, as they call it, in that religion or whatever, you've gone. But the point is, when you're old enough to understand that you have a choice and you are free, if you've been taken into a society or a religion or a cult or anything, if you're
I think they call it coerced, John.
if you can, yeah, that's one word for it. But if you're in the position whereby you understand what's going on, you have a right to say, no, I was born free, I'm going to be free. So what we're doing is the easiest way to do it, because there's nowhere in the world just now that we knew of at the time when it happened that you can actually confirm that you're living. For example, if I turn around to someone watching this, in most cases, people may not know. So if I ask them for ID, they would then go and say, right, okay, that's fine. They hand you a bank card, a driving license, a credit card, a passport, all these things. But that's not for you as a living man or woman.
Yeah.
That is for the statutory corporation, the statutory identity, to confirm that you're in their system.